Hi guys, it's Kathy. I hope you're doing well. I hope you are well rested. I am well rested. This week won't be so bad. Don't worry guys, everything's going to get back to normal in a little bit. I'm working on it real hard. But until then we gotta just struggle through it. I don't know about you guys, but oof, the world is crazy right now, isn't it? Seriously, people are not doing good right now, guys. When you go out, you're outside your house, people are not thriving at all. We gotta try to be extra nice, guys. It's too much. It's too far. People are too brother against sister right now. Friend against friend. We gotta snap back to where we're supposed to be. You know? Not you, Bobby. You're the same. We know that. We gotta be nice to people today. Try to be really, really nice to someone today. Maybe try to look, guys. Maybe go the extra mile and try to be nice to someone you might dislike because of reasons. We have to. This isn't how we're supposed to be. Oh no, Chekhov is at the vet. V, thanks for the cheers. I appreciate that. I do. I don't know what that is, but it sounds horrible. Is that for your throat? They're not scraping it again, are they? I don't want them to scrape it again. You go through so much hell when they do that. Guys, when I said be nice to someone today, I didn't mean be nice to Bobby. Yeah, you don't have to be. We're just kidding, Bobby. No, forget it. He said lock everyone up. Don't be nice to Bobby. Oh, because of your medicine. It's one thing after another. As soon as you get home from that, Kelly, they'll say, oh, you got an inspection coming. Maiko, you never stop giving. Never. You never stop going the extra mile. That's why we love you. Alright, we're going to go through a little bit of this judge. 10 minutes. And then we're going to pop over to another courtroom. Okay. Let's go. Let's get our court on.
Better day?
That works.
Okay. If for some reason that wouldn't work, just stay in touch with your counsel and we can probably rearrange it, okay? All right, thank you. All right, gentlemen in the back, anybody who not have an attorney?
I'll say.
Okay, what's your name?
Mastriano.
I'm sorry, last name?
Mastriano.
Yeah, okay.
Mastriano.
All right, thank you. All right, sir, this is 26M3464 and 26M3301. Both these matters come on for pretrial readiness. Trial on both cases is set to commence August 20th. People.
People are ready, but we are concerned because the defendant has not requested discovery.
I actually had, Your Honor.
You have it?
I do. I turned it into the courts as well. This is their copy.
So you have the discovery?
No, not the discovery. I have the motion for it.
So are you ready for trial on the 20th of August?
Yeah.
You're going to pick up discovery before then, so you know what the police reports are that they're using to prosecute you?
I imagine, yeah. There wasn't too much to it, so.
Okay.
I imagine I could be able to pick it up before the 20th.
How about you head over there when you leave the courthouse?
Yes, ma'am.
105 East Vermont. Just
that
a little
that was the time.
hop, skip, and a jump over there, okay?
Yes, ma'am.
So you're ready for trial, sir?
Yes, ma'am.
And people are ready?
Yes, people are ready.
Okay.
And is you aware that there's two cases to request discovery?
You have both cases?
Okay, I only requested them on one,
Okay.
so I could get the others.
You know the case numbers? Let's write down the case numbers for Mr. Bedrome and Mr. Fiona.
Well, you're on case in this case.
Appreciate you.
And when you go over there, put both of them in. You need to let them know you're in trial on the 20th, so you need that stuff before then. I mean, we're far enough. I know this is an early pre-trial readiness just due to the court schedule, but.
Now I'm going completely opposite of what I said. Not be nice to someone else, but be very mean to Bobby. Just be mean to Bobby. Bobby, your shirt's wrinkled. Oh, you're not wearing a shirt?
That they would come up quick, sir. Okay? All right. Any outstanding issues other than that at this point?
I have a motion for the discovery as well as a couple others that I filed in. Maybe it was a little late. They hadn't made it up to you yet, but I do have some in.
Well, when were we planning on hearing those, sir? They're due 28 days after you file guilty pleas.
Right.
And, okay,
I'm still within that window, correct?
within that time, I don't have any motions from them.
I just filed them this morning.
And what are those motions?
I have the notice of affirmative defense,
Okay,
the answer. I have motion for discovery as well. Also, motion for Lamine.
motion for what?
Lamine,
Eliminate?
is that how you say it?
Motion and eliminate.
Just that appearing pro se respectfully requests that the honorable court enter prohibiting the prosecution from introducing at trial any evidence reference to any of my previous cases,
Okay,
being that they're unrelated, and it would cause unjust
okay.
negativity
So
towards the
people
case.
haven't filed any requests to me to be able to do what we call 404B, prior act.
Right.
Or prior crimes. So they know that they are not allowed to do that. So they will be prohibited because they have not filed anything in the case to be able to introduce that. Okay, so.
Just wanted to make sure. I believe that's it.
Okay, so the affirmative defense, can we make copies of all those motions while Mr. Bedrome Mastriano is present? You don't really do a formal motion for discovery because it's self-executing. You just have to, I just need your motions.
Oh.
Are those all the motions?
No, there's also it.
Okay, I just need the motions so we can make sure the DA has a copy and whatnot.
Don't be your own lawyer, guys.
Okay? And so discovery is self-executing, but you have to ask for it over there, okay?
Okay.
I don't release discovery.
I didn't realize I applied, but yes.
So head over to the district attorney's office, and so no prior acts are coming in. I will tell the court that I will tell the jury on jury trial day that you're representing yourself and they can't hold that against you, and that's your choice. But other than that, it doesn't sound like the people have any motions that they have filed.
Okay.
And that was your only motion except for your affirmative defense, which they're entitled to notice of, so we'll make sure they get that today.
I also have some evidence that I was going to turn into them as well if it's appropriate.
Okay.
I also have it turned in downstairs.
Okay, is this evidence that, because you don't have to turn over anything to that evidence, Ross.
I know.
Okay,
No, this is it's necessary, I feel.
okay. And so you're ready to turn that over to them today?
Yeah.
Okay, so,
Yes, sir.
all right. So we'll go ahead and do that. I think it might be prudent, given this, that we have a pre-trial readiness the day before trial on the 19th. Okay, so why don't I have you come back on August 19th?
Hi, Terry.
At 10:30, sir.
Okay.
And because maybe the DA will look at your evidence and maybe they'll say, we're not going forward. I don't know, okay? But please go over and get your discovery from the DA's
As soon
office.
as I leave here, Your Honor.
There's probably also body worn cameras, so you're gonna wanna make sure, not only do you want all the written discovery, you want the body worn camera stuff,
It's
okay?
all in the motion, ma'am.
Okay, all right.
And Your Honor, if the defendant does testify, we do have about the conviction.
Okay, that's fine. Okay, so what she's saying to me is she's not going to bring it out in her case in chief, but if you were to take the witness stand, the court is going to give you an advisement. It's called a courtesy advisement. It's all about your rights to testify or not testify. And during that advisement,
Hi, Jerry.
I do advise defendants that if there's a felon conviction, the people will be entitled to ask you about it if you testify. So that's what she just said to me. It's like, Judge, he needs to know that even though we're not bringing those priors in the case, if he testifies, we would elicit that, okay? But I would be giving you a full advisement on that. But she just wanted you to be aware before you left today, okay? All right, any questions for me, sir?
No, ma'am.
Okay.
I think so.
I'm gonna see you back on the 19th at 10:30, and that's gonna be our second pretrial readiness, and we'll see where we are based on everything that you tendered today. And I'm really hoping you have discovery by then, okay?
Hopefully as well.
Okay.
I do have actually a question. Would it be appropriate for me to turn in evidence after this point?
Well, I guess I don't know what it is. And so
What it would be?
you never, please,
Sorry.
I just want to make sure you understand. As a defense, you never have to release your evidence to the prosecution. You
Right.
do not have to give them your evidence.
Right, but it may cut us all a break.
Okay,
So to
if
speak.
you feel that it is beneficial to your case and you want to turn it over to the DA, that would be on you, but I'm just telling you, the defense never has to turn their evidence over to the prosecution prior to the trial. Okay?
Yes, ma'am.
Yes, Your Honor. If there is further evidence, you would just need to go to our office.
Right.
And ask to turn it over to an investigator, and they will provide that information.
All right. All right, sir, I'm gonna see you back on the 19th of August, okay?
Thank you, Your
10:30. Thank
Have a
you.
good day.
Thank you.
He thinks he's gonna give him a screenshot and they're gonna drop the case. That's what he thinks.
All right, Mr. Medina, I see you here. Is Mr. Cellini gonna join you?
Not today, Your Honor. There was another conflict today on the ADC, Lauren Tolley instead of Mr. Cellini.
Oh, well, he has not filed a motion in this case.
And I just made bond yesterday, so I haven't been able to contact her this morning.
Okay, when did I didn't look up your felony because I figured, Mr. Cellini would be advising.
The 20th.
20th of August?
Yes, Your Honor.
Of course, it's always on a Thursday when I can't.
Always, it always happens to us.
That's what I'm gonna do. It's on the section on the 21st at 8:30. I'm gonna look at the felony.
Not only that, V, I'm positive they found ways. They found ways to do it cheaper. They just did. You know, it's all right. I think the world is going that direction. I think the world is sick and tired of the greed. I think they're going towards the direction of stopping it. I think people are just too mad. You know, we can only hope. It probably won't be, you know, in our lifetimes, but I think the world is going in a different direction for our children's children, because it's just too much greed.
And see if we can get Ms. Tully appointed on this as well, okay?
Yes, Your
All
Honor.
right. So we'll see you on the 21st at 8:30, Mr. Medina.
Thank you, Your Honor.
Thank you. I have a Alex Espinoza on WebEx.
I have a breakout.
Sure. Mr. Espinoza, can you hear the court?
Yes, I can.
Oh, Ms. Espinoza, I apologize. Your attorney's going to go into an electronic room with you. You're going to be outside the presence of the court. He's going to have a little conversation with you, and then I'll bring you back into the courtroom, okay?
Thank you.
Thank you. All right, I have a Mr. Harrison on
No.
WebEx. All right, that's Mr. Rodemer's case.
Yes, sir.
Mr. Wooten?
And
I'm bumping it forward 1 minute because we're done. It was just the pro se guy. All right. We're just going to watch a few more seconds.
A Mr. Harrison on WebEx. All right, that's Mr. Rodemer's case.
yes, sir.
Mr. Wooten?
And I apologize. I spoke with Mr. Harrison. He was under the impression that the court was at 10:30 today. I told him to log in. Otherwise, he could be down here by 10 o'clock. He said if he'd like me to appear in person.
Okay.
I'm on my way right now. I apologize.
Okay, well, all right, hang on.
Kelly, 26 CR 1489. Ms. Bramble, we'll start with you.
Thank you, Your Honor. Mr. Kelly is electing to waive extradition, so we would just ask for a fugitive review of that extradition in 30 days.
All right. Defendant waives extradition. We'll set this for review in 30 days. This will be set for an administrative review on August 31st. The fugitive unit is directed to notify the court when the defendant has been delivered into custody of the demanding state, which is Tennessee in this case. It'll be Division 8 that is reviewing that. And we still need to set a bond or don't need to set a bond.
At that point, Your Honor, we don't.
All right. And I'll sign that order now. I'll be given another order to sign. I'll sign those during the docket today. And that concludes that matter.
If Gilpin County is ready, we could get started on those Gilpin cases.
All right. Ms. Bramble, do you know which Gilpin case you have ready? Or which one's up?
Actually, we have both of them ready. I'm not seeing anyone on the screen yet from Gilpin.
I heard him a moment ago. Can Gilpin turn the camera on? There we go. Is that Miss Shea?
Yes, Your Honor.
All right. Court finds probable cause for arrest. People, your bond argument.
Thank you, Your Honor. And Kyle Ederle for the people today. I believe on this case, bond is set at 10,000 cash or surety on the warrant. I would ask that bond remain as set, and I would object to any reduction. The defendant has 22 previous failures to appear, a pretty extensive criminal history as well. But the facts here allege there's so many victims here. The defendant went to 2 casinos, was going through cars at one casino, stole a car, and drove it to the other casino, used a stolen ID to get a playing card, broke into a car by smashing the window. There was just a lot of damage done here. So in addition to the 10,000 cash surety, do not return to the Century Casino at 102 Main Street in Central City, and the Grand Z Casino at 321 Gregory Street in Central City. No contact with the protected parties. And I'm going to ask for a few protection orders here. These people all either sustained property damage or something similar. I'm asking for Jamie Laro. And let me know if any spelling or dates of birth are needed. Haley
Just a
Young.
moment.
Sure.
Just a moment.
Sure.
How many are you going to ask for? I have about a dozen.
I'm going to ask for about 8.
All right. So Jamie Laurel, next.
Haley Young. And then Rocky Peruse. And then Lathrin and Thomas Durden. Leroy Anderson. David Macias.
Is that it?
And then the last one's Chibueze Major, and I apologize for any mispronunciation there. I would ask.
Did you ask for Leroy Anderson?
I did.
All right.
Yeah,
So
and
Leroy
Boston.
Anderson, Catherine and Thomas Durden, Kelvin Onyemehor, Jamie Leroux, David Macias. Did you ask for Taryn Lynn San Lorenzo?
I don't believe I requested those ones.
Which ones?
Those 2 that you just said.
It was one, Taryn Lynn Sorenzo.
Correct. I did not request.
All right. Haley Young,
Yes.
Rocky Barus.
Yes.
Ms. Bramble.
Thank you, Your Honor. I'll start with my statutory and constitutional bond argument that I'll incorporate into all my cases today. Starting with Colorado does have a presumption in favor of pretrial release. So we are asking the court to convert the bond to a PR bond. We are objecting to any sort of cash-only bond setting, and the court shall presume that all persons are eligible for release with the appropriate and least restrictive conditions, citing to 16.4.103.4a. Money is restrictive for someone without means, which
JK, thank you so much. 19 months. Oof. Hi, Lisi.
does include Ms. Shea, who has advised she does not have any financial means to post a monetary bond. The court shall avoid unnecessary pretrial incarceration, citing 16.4.103.4c.
Monica, thank you so much for the cheers. I appreciate it. Thank you. Thank you.
Pretrial incarceration due to the inability to pay bond is unconstitutional, as it violates both equal protection and due process at the U.S. Constitution at Amendments 5 and 14, and the Colorado Constitution, Article 2, Section 25. Money bail that is the functional equivalent of no bail is a de facto unconstitutional pretrial detention, contrary to the Colorado Constitution at Article 2, Section 19. The court must select the least restrictive bond and conditions of release. So whether cash, property, PR, surety, and conditions of release, no matter what the court sets, they must be based on individual characteristics and financial condition, citing 16.4.103.3a. Any monetary condition must be reasonable, citing to 16.4.103.4a, and non-monetary conditions must be tailored to address a specific concern. Now, more as to Miss Shea individually, it looks like she does have a working phone number, so she can stay in contact with a lawyer if she chooses to have one, pre-trial if she needs to, get on the court notification system to make sure she doesn't miss her court dates. She also does have a specialist doctor appointment in Aurora on Thursday. It sounds like related to potential.
Anytime, V. I have everything I need. I'm just lazy. It's lovely not having a camera. All right, Jude, thank you so much. I cannot like that. I could not thumbs up it. I'm clicking. It won't let me. But I do appreciate it. Thank you, thank you, thank you.
Condition, a neurological condition. She does have consistent employment at Olive Garden in Aurora. She's been there for 2 years. She is.
The biggest thing is there's this ceiling fan. And I'm trying to figure out where to put the green screen around the ceiling fan. If I have to put it behind the ceiling fan, which means it would like cut off most of my room and leave me a tiny little sliver to walk to the bed. Which I guess is fine. I don't need a big sliver to walk to the bed, right? I'm not as wide as I am tall. so I don't need a big spot. I just need to get my green screen up. That's all I have to do. It's this house, I mean, I love it. It's like an old, very old farmhouse. White farmhouse way out in the country. But one of these days, the steps are going to kill me because the steps are not all the same size. And there's one that's significantly, like 3 inches higher than the rest. They cut it and added it because they wanted to put this washer and dryer, you know, one of those tiny units where the dryer is on top of the washer. They wanted to put that under the stairs. So they cut the stairs and raised this one stair like 3 inches. So it's, sorry, it's like I go halfway. The stairs are really wide, which is good. Like I can carry a laundry basket sideways. I don't have to carry it long ways up the stairs. The stairs curve though. So the stairs though, it's that one step is a problem. There's another step that's really, really, really loose. I feel like I'm going to fall right through it when I walk on it. But the problem is The steps aren't like flat. It's a really old house. So over time, the window at the curve in the step, the glass is all you know, wavy because of time. You know, glass is liquid, and over time it so the glass is all wavy, which is gorgeous. I just think it's gorgeous. But the steps are also wavy. They're gonna kill me. They really are gonna kill me one day. I gotta hold on tight to that banister. I go up and down the steps every day, but when I get to that one step, up or down, it's like, oof, I make a noise. I don't know how to get up that one step without making a grunt or a noise. My poor kids have to hear me grunt every day. But yeah, my room is a bit messy. Yes, I don't care. I don't have a husband or boyfriend. I can throw a sock on the floor and leave it there for 7 years if I feel like it, or I can pick it up if I feel like it. It's just there seems to be significantly less amount of socks on the floor now that I'm single, though, than when I was married. You know what I mean? But the thing about my room is I know if I put a shirt down somewhere, I have to clean that up. But I put it there and I clean it up. You know, no one is coming into my room, throwing something on the floor and then expecting me to clean it up later. So yeah, when your job is cleaning, you go home. It's funny because, you know, when I'm at work, like, you know, I'll vacuum, I'll lift the table, like grab the table by one side and pull it high up so I can vacuum underneath the legs. And here I just vacuum around the cats. I'm really, really good at work. But by the time I get home, I'm like, oof, no, let's just take the top layer of dirt off so it looks kind of normal. And the rest, well, you know. Oh, I could, Jude, I could do a stained glass effect in that window because it's not like the panes aren't square. The panes have like these triangle designs in them. It's a real old window. But I gotta scrape down the paint and repaint because all the paint is peeling off. The house looks atrocious. If you see it from the outside, all the siding, they fixed the siding. They scraped and repainted the siding, like for the first story, but then for the second story, it's still peeling off. So like the bottom half of my house is perfectly white and beautiful, and the top half looks like a horror movie. And my roof looks like a horror movie, but that's okay because I've not yet been to my attic. I've not yet opened the door. It's too scary. I don't want to go up to the attic. It's too scary. But I did go to the basement yesterday for the first time since I moved in. And the basement, you can't get to the basement from inside the house. Hi, CJ, love. You have to go outside the house and around to the side, and then you can go into the basement. There's a huge snowblower. A humongous snowblower. I'm so happy because the driveway is so long and stone. And I'm like, how the F am I going to shovel this driveway? I had no idea how I was going to do it. I'm like, oh, I got to buy a snowblower, but they're so expensive. I think it might be like a Toro or something. It starts with a T. I have it right here, but it doesn't matter. But but I'm just so pleased. I hope so. It looks brand new. It looks all red and shiny and huge. It's not a dinky little $100 snowblower. It's a huge red big blower. Like I'm gonna struggle just to get it out of the basement. The basement doesn't go down. The grass hill goes down. So when I walk around the side of my house, I'm walking down the grass. So when I get to the side of the house, I go straight into the basement. So I'll be able to take it straight out. There's no steps or stairs or anything. I guess you can snow blow grass, right? I can snow blow from my basement up the grass hill to the driveway, right? I don't know. I've never used a snowblower before. I've always shoveled. My whole life. I've lived in Pennsylvania my whole life. Lots of snow. And I never had a snowblower. Very few people I know had a snowblower. Has the guy across the street had one, but he had a landscaping business. So that was like a bit. We just all went out and shoveled every morning. You know, it's a good quality blower, Bobby. It's not like not Roku. What do you call Roby? I don't know if Roby makes snowblowers, but it's not that. It's a good one. I just need to figure out a way to fix my stairs so I don't kill myself in this house. But no, CJ, snow is great. It's so beautiful when it falls. Like, the whole world is quiet. There's like a soundproof. It's just so peaceful, and I think it's a Toro. I think that's what it is. It's red. I have a picture of it so I can tell you what the brand is. But it's huge, so that's why I think it's a real nice one. I'll look. I'll see. But I'm going to get back to... We're supposed to be watching court videos.
Concerned about losing any stability that she has if she's not released. She's out of the same apartment for 2 years and lives there with her 2-year-old daughter, who's currently with her father. But of course, Ms. Shea is concerned about not being out to be with her daughter, who is so young. She's been in Colorado for 10 years. She has a lot of family in the state, including parents who she helps with bills and housework as they're getting older. Her 2-year-old daughter.
It's just so invigorating when you go outside and it's like, 10 degrees or even a little below zero. Like, the air is just different. You know what I mean? It gives you all this energy. Not like the summer heat is so stifling.
As I stated, the father of that child, even though they live separately, and she also does regularly volunteer at a soup kitchen in Aurora. It looks like about 3 times a week, and has been doing that for about 3 years. She is used to using public transit, so that wouldn't be a problem to make sure she can get to and from her court dates or anywhere that she would need to in order to stay in compliance with her bond conditions. So overall, she has pretty significant stability. She has a lot of people relying on her, and so we would ask the court to give her a chance on a PR bond with non-monetary conditions to secure it so that she can maintain that stability. We would object to any sort of cash-only bond setting.
Court's going to order a $10,000 cash or surety bond. Do not return to the Grand Z Casino, and do not return to, which is the other casino?
Century Casino.
Century Casino. Court's going to enter a mandatory protection order, boxes 1 through 3, for all of the following of VRA finding: Jamie LaRue, Haley Young, Rocky Baruce, Leroy Anderson, Catherine Durden, Thomas Durden, David Macias, and Haley Young. And on Thomas Durden, I need his date of birth. I've got 120 and then I mistyped the year.
I believe that's 1961.
All right. This will be reset. Can you waive reading?
Yes, Your Honor, I'll wait for the reading and advisement. Ask that the public defender be appointed while Michelle remains in custody and for a preliminary hearing date within 35 days.
Find the reading's been waived. I'll find the defendant is indigent. I'll appoint the public defender. This will be reset for a preliminary hearing on August 10th at 1 p.m. and that'll be in Gilpin County. And that'll conclude that matter. Give me one moment to finish up these. Make sure I got all of them. Thank you. And pre-trial, just let us know when we can go to the next.
Is the second Gilpin matter ready?
Um,
Good morning, everyone. Thank you.
Good morning. This is Darby Welch.
I was wrong. It's a Troy belt, not Toro. Troy belt, 24-inch. 6 speeds forward, 2 speeds reverse. 2-stage power, electric start. Snowblower. Oh, it's called a Storm 2410.
26M289. Miss Cynthia Welch is present. Would like to address the court. Ms. Welch, let us know what you'd like us to know.
I am Darby Welch's mother, and Darby has the DD waiver under Healthcare Policy and Finance. His case manager is with Jefferson County Human Services, and he has an agency as well, and Oasis Aid. And Darby, it's mental health services under the DD waiver are voluntary. And I, Your Honor, I would like to request that I was informed about a competency program. I would like to request that Darby receives mandatory mental health services since he will not utilize any of the mental health services or resources on his own accord. Darby resides with me in my home, and I think that if he has these services, he will begin to improve. Darby has had a lot of self-neglect in the past year. He eats very sparingly. His mental health is in decline, and he was at Lutheran on March 28th, and they felt that outpatient would be best, even though Darby at that time was amicable. He was agreeable to go to such as Highlands Behavioral for, to get these mental health services, medication management. But once he came back home, he declined to get these. He has massive anxiety. He never leaves the home, and he will not do the outpatient. He's too nervous to get into a vehicle and drive, etc. And he needs mental health services, very much so.
Ma'am, any input on a protection order protecting you and keeping him from being in your home?
I don't want to have a protection order. I want him to get help. I don't feel that Darby is going to harm me physically. As far as keeping him in my home, I want him to get help. And under the DD waiver, he also has the ability to go to a host home. And I think that too would be good for him. But I think first and foremost, he needs to get help. There is a host home that is available for him right now through his agency, Oasis Aid. And I think in conjunction with him
having mandated mental health help, support services, resources, and him being willing to try out this host home, I think that would be good.
Thank you very much.
Thank you.
Mr. Etherly.
Thank you, Your Honor. I don't object to a PR bond here. I would ask for a mental health evaluation and treatment if the defendant were to consent. I think that could help here and would make a lot of sense. For the time being, I'm going to ask for no contact with Cynthia, no weapons, a box 1 through 5 protection order, and to comply with the protection order.
She's my family caregiver, so I have nowhere else to go.
Mr. Welch, do not speak on the record. I will speak on your behalf.
Okay.
Ms. Bramble.
Judge, we are also asking for a PR bond.
I would do a PR bond, sorry.
Oh, okay. That's what we're asking for, Your Honor. I don't know that a full no contact protection order really makes sense here, given the record that we just heard from Mr. Welch's mother. But I'll defer to the court.
And is your client willing to do, it would make more sense to participate in mental health treatment. It sounds like evaluations have already been done.
Yeah, based on the information that I have, it seems like that'd probably just be as much as signing a release of information to pretrial. So I'm sure Mr. Welch will cooperate with that.
Your Honor, if I may, my mom's being paid to provide.
Ma'am, sir, your attorney has spoken for you. I'm going to set bond at $1,000 PR bond. I am going to enter a mandatory protection order. However, it'll be boxes 1, 4, and 5. The protected party is Cynthia Welch. What that means is that you may not, and Ms. Welch, I'm going to ask you to come up, provide your date of birth so we have that. What that in just a moment, not on the record. And what that means is that you cannot harass, intimidate, or retaliate against your mother. You may be in the home if she allows you to be in the home. You may have face-to-face contact if your mother allows that. You may not have any weapons and you may not have any ammunition. Conditions of the bond are to participate in mental health treatment. And this will be reset in Gilpin County for an arraignment on August 11th at 8:30 a.m. And that concludes that matter.
Okay, thank you.
You're welcome. Thank you, Ms. Bramble, for your help there. She'll give you that date of birth. And just to the clerk, and I don't want it on the record.
Thank you, Your Honor.
You're welcome.
164.
Up next, we have Boyer.
64.
You said Boyer?
Yes.
This is Rita Boyer, 26 CR 1483. The court finds probable cause for arrest. People?
Your Honor, I believe the victim is present at Porch Light and would like to address the court.
And is that Murray Boyer? If so, please just state your name for the record and please tell me what you'd like me to know. I don't see anybody there.
She's coming to the podium, please.
Mind if I sit right here?
Well, we're going to have you walk straight up to the podium and actually do that with the judge. We'll put a chair right behind you.
Okay, I think he can hear you now. Go ahead.
Yeah. Hello, Judge.
Good morning to you, Mr. Boyer. Would you state your name for the record and then please tell me what you'd like me to know?
Murray Ross Boyer.
And what would you like me to know?
Oof. CJ, they're delicious cakes.
No, sir.
That I'm tired of my wife beating on me.
All right.
All this stuff assume her hitting me. For no apparent reason.
Want to tell the judge about what you want for the protection order?
Yeah. Yeah. I do want a protection order. I just don't want where she can be around me and hit me or nothing.
Anything else you'd like me to know about a potential bond?
I don't know what you're talking about. You'll have to explain things to me. I'm really slow.
All right, so Mr. Boyer, here's what we're going to do. I'm going to hear from the people of the state of Colorado, Mr. Etherly first. He's an attorney. Then I'm going to hear from the defense attorney, and then I'll make a decision as to what bond will be and that protection order that you asked for.
Okay.
All right, Mr. Etherly.
Thank you, Your Honor. My notes indicate that the victim may have wanted a low bond. So I'm not sure if that's still the case, but I'm on the fence here. I won't object to a PR bond, but I am going to ask for no contact and a full no contact protection order. The defendant is a CPAC category 1, but the history is concerning in that there's a history of assault with this victim. There's 2 hands-on DV cases. In 2012, a DV assault, 2018, a harassment, strike, shove, kick, and then a protection order violation. So her only criminal history is DV and for this victim. So I am very concerned about that. So I'm going to ask for no contact, a box 1 through 6 protection order, no weapons, comply with the protection order, and finding of domestic violence and use of force. Thank you.
I would do a PR bond in this case, Ms. Bramble. Ms. Bramble?
Sorry, Your Honor, I didn't realize I was on mute. That is fine, Your Honor. I would just also ask for a civil assist.
All right. So the court's going to order a $1,000 personal recognizance bond, pretrial services, no contact with Murray Boyer. I'm making a physical use of force finding, ordering firearm relinquishment as a condition of both bond and the mandatory protection order. I'm entering a mandatory protection order boxes 1 through 5. What that means is you cannot have you can't harass, intimidate, or retaliate against Mr. Boyer. You cannot be in the home with one exception. I will authorize the civil assist. What that means is you will have to contact the local police, arrange a time for them to be at the home so you can remove your belongings. You can only be at the home when the police are present. In addition, no face-to-face or third-party contact with Mr. Boyer, no weapons, no ammunition, and you have to relinquish firearms. I'm making a domestic violence finding and a victim's rights finding. This will be reset for filing of charges on August 6th at 10 a.m. If you wish the public defender to represent you, you'll need to have, you'll have to reapply. And this hearing will be in courtroom 110, and it is an in-person hearing, and that'll conclude that matter.
Judge, just to clarify, did you say boxes 1 to 5 or 1 to 6?
1 through 6.
Thank you. Up next, we have Murphy.
Ask me what you're asking. So there's somebody named Vanessa that needs to answer the chat from the clerk, and she's on WebEx. And you called Katana Murphy. This is Miss Murphy. This is Katana Murphy, 26M4022. Court finds probable cause for arrest. Mr. Etherly.
Thank you, Your Honor. I believe the victim's on WebEx and would like to address the court.
And is this Mr. Williams? If Mr. Williams present, all you have to do is state your name and then please just tell me what you'd like me to know, sir. I'm not hearing anyone. Mr. Etherly.
The notes I have here indicate the victim's requesting a PR bond. They share a child that needed to communicate. The victim says defendant's planning to leave the state to get family support, and victim does not object to that. Your Honor, I'm asking for a $500 cash bond here. My concern is that the defendant would leave the state, as has already happened. Looks like in 2025, the defendant picked up a DV assault case and then left Alabama, and there's a current warrant there. So my concern would be she's already left one state after a DV incident, then picking up a second incident, what is clearly indicating or planning to leave the state again. So I do have concerns about appearing at future court dates and ties to the community. Given the plans to leave the state, I think that maybe even over $500, maybe $1,000 may be appropriate. Given again the history of picking up DV cases and leaving the state. No weapons, no contact with the victim, a box 1 through 6 protection order, and to comply with that protection order, and finding of domestic violence and use of force. Thank you.
Ms. Bramble.
Hi, Cosmic.
Thank you, Your Honor. First, I'll
Oh, I'm
incorporate the statutory
sorry.
and constitutional bond argument in the open case 26 CR 96 into this case. As to
Hi, Gina.
Miss Murphy, she's a CPAC category 1. She has no prior convictions. I'll note that I don't think there's enough information about whatever the Alabama hold is for the DA to impugn upon Miss Murphy wrongdoing, to know what the allegation is, the status of the case, or anything at all about the court proceedings besides one entry in the pretrial report, especially since it doesn't look like there's an extradition hold. So, Your Honor, the victim's not objecting to a PR bond. I would guess that that does lend itself to the idea that Ms. Murphy is not going to be a danger to her family members. She, it looks like, does live with the alleged victim in the case, and so she says she can arrange to stay somewhere else, but ultimately a no contact protection order may make her homeless. So we would ask that it not be no contact, but box 1 only. While Ms. Murphy has only been in Colorado briefly, she does understand that she needs to stay in Colorado for the duration of the case, and she is happy to do that. She is comfortable taking public transportation to make sure she gets to and from her court dates, and do anything else she needs to stay in compliance on bond. She's been trying to find a new job. She is used to working in the service industry doing waitressing and has been looking at similar jobs here. And so, Your Honor, I don't think there is anything on paper that suggests that Miss Murphy cannot be safely monitored in the community. And ultimately, since the victim's not objecting to a PR bond, I think that should also tell the court that that is more than appropriate. We would object to any sort of cash-only bond setting.
The court's going to set bond at $2,000 cash or surety. And who was that? Was that the victim wishing to talk?
I do have additional VRA position to relate to the court.
Yes, go ahead.
The victim is also requesting contact in public places and communication regarding the child and finances. Sorry about that, Your Honor.
All right. Court's going to order a $2,000 cash or surety bond. Appearance in court is the concern, statutory concern, pretrial services, no contact with
Good morning, Josh.
Antonio Williams, with exceptions, which I'll get to in a moment. I'm going to find a use of force. I'm going to order relinquishment of firearms. I'm going to enter a mandatory protection order. It will be boxes 1 through 6. You can't have any contact with Mr. Williams, can't have face-to-face contact with him, cannot be in the home, except for I'll authorize 1 civil assist, and I will authorize electronic communication. That means by phone, text, email, or social media. I'm not authorizing any face-to-face contact with Mr. Williams at this time. I'm making a domestic violence finding, a VRA finding. We'll reset this for an arraignment on September 8th at 10 a.m., and that'll be in Division D, and that'll conclude that matter.
Up next, we have Gutierrez.
This is Jana Gutierrez, 26 CR 1485. Court finds probable cause for arrest. Mr. Etherly.
Thank you, Your Honor. I'm asking for a $2,500 cash bond here. The driving that was observed here is concerning the defendant ran at least 3 red lights before hitting another car. And then the passenger in her own car sustained SBI, which is like left distal radius fracture. She admitted to drinking, and by her admission, only 1 beer appears to be enough that would make her unable to operate a motor vehicle. She failed to perform SFSTs as a sober person. So this whole situation is concerning with the level of intoxication.
Dear Lord, you know how much money I would save? Do you have any idea how much money I would save if 1 beer made it so that I could not operate a vehicle? Oof.
The driving and the injury. She also has a 25 CR case that is currently a warrant. So I do have concerns about another recent case. In addition to the cash bond, pretrial supervision with monitored sobriety, no drugs, no alcohol, no driving without a valid license and insurance.
Hi, Hedwig.
Box 1 through 5 and 7 protection orders for AGS and I'm sorry, I think I can say the names, and Lila Lawrence. Thank you.
And Ms. Bramble.
Thank you, Your Honor. I'll incorporate the statutory and constitutional bond argument and Gilpin 26 CR 96 into this case. As to Ms. Gutierrez, she's a CPAT 2 with 1 prior shoplifting and warrant status. I'll correct the people and say it's not a 25 CR. Looks like it's a general sessions case. It's a shoplifting. So it's not another felony accusation. That is the entirety of anything in Ms. Gutierrez's history. It would be appropriate for her to get a chance on a PR bond to with sobriety monitoring so that she can potentially have an opportunity with treatment. She can be safely managed in the community with as much as conditions like electronic monitoring if the court finds that heightened sobriety monitoring is necessary, or a condition to not drive without a valid license with this pending charge. Certainly that would address the concerns that have been expressed and the concerns that might be raised by the affidavit. Ms. Gutierrez does not have a significant amount of money to post towards a monetary bond. Additionally, it looks like she does have a pretty serious asthma diagnosis that requires medication twice a day, as well as anxiety, depression, and an ADHD comorbid diagnoses that certainly would require follow-up care. Looks like she works at Mountain Prime in Idaho Springs as a hostess. She was wanting to go to esthetician school in the fall. Certainly that's probably going to be on hold while this case pens, but it's good to know that she has been making plans for the future to move forward in her career. She lives alone in her apartment in Golden. She's been there for 10 months. She used to live with her parents in Golden, but has found this stability newly since she is only 20 years old. And she's been in Colorado for her entire life. Parents are here, brother, grandparents, cousins, aunts, uncles. Her entire community is here. She has a church community that she attends every Sunday at Hilltop, and significant family that can not only support her during this process and make sure she stays in compliance with conditions, but also give her rides to her court dates, to pretrial appointments, anything she would need to stay in compliance. She has very significant stability here. She has a lack of criminal history. All signs point to giving her a chance on a PR bond with admittedly probably more heightened sobriety monitoring to ensure that she is taking her sobriety seriously but I know that she is willing to do that for the sake of showing the court that she can be safely monitored in the community. So we would object to any sort of cash-only bond, as that would be a de facto pretrial detention of Ms. Gutierrez. We would ask for a PR bond.
Court will set bond at $25,000 cash or surety, pretrial services, no alcohol or drugs, no weapons, and no contact with Alba Serrano and Lila Lawrence. Monitored sobriety at pretrial services discretion. Entering mandatory protection orders, boxes 1 through 3, which means you can't harass, intimidate, or retaliate against either Alba Serrano or Lila Lawrence. Can't have any face-to-face contact with them or contact with them in any other manner. I'm making a VRA finding as to both victims. This will be reset for filing of charges on August 6th at 10 a.m., and that'll conclude that matter.
CJ, if you're still here, I was thinking about you yesterday hard. So I was at the grocery store, and so in Pennsylvania, to buy liquor, you go to a liquor store. It's a state-run liquor store, and that's where you get, liquor, not like beer and wine. You can get that other places, but I'm at the grocery store, and right beside it is the liquor store. And, I thought, you know what? I'm going to go buy some champagne. And I did. I went in and I bought some champagne, and now it's in my refrigerator. It's not real champagne, it's Prosecco, but it's the same difference. Because I just think that this month I'm going to need champagne. I don't know why, but I bought champagne. It's in my refrigerator, and now I'm just waiting to see why I bought it. I think I'm going to need it this month. But as soon as I saw the champagne, I thought of you.
Up next, we have Vigil for filing.
This is Denise Vigil, 26 CR 1458. Ms. Bramble.
Thank you, Your Honor. We'll waive further reading and advisement. Ask that the public defender be appointed while Ms. Vigil remains in custody, and for a preliminary hearing date within 35 days.
Find that rating's been waived. Defendant is indigent. Appoint the public defender. This will be reset for a preliminary hearing on August 26th at 9:30 a.m. in Division D. It's Division D, 14 case. And that'll conclude that matter.
Up next, we have Fuqua.
This is James Fuqua, 26 CR 1484. Court finds probable cause for arrest. And it appears Miss Cynthia Fuqua is present at Porchlight. Miss Fuqua, if you could state your name for the record and then please tell me what you'd like me to know.
Cynthia Fuqua.
Excuse me, Fuqua.
Fuqua. This is my husband of 38 years. He's not a bad person. He's not a bad man. We've gone through a lot for 40 years. And I can't lose him. And I needed him healthy. And I don't know how to do that because I can't get him to do it. I'm so sorry.
It's quite all right, ma'am.
He just needs some help. He doesn't need to be in jail. He just needs to get some help.
Ma'am, is there anything you'd like me to know regarding a protection order?
I believe it's important that we have some kind of contact because I've always been his support system and he's always been mine. I just want him back. I want my husband back. I want him healthy. It's the mental health. This guy's, he is a retired firefighter paramedic. He has saved so many people. And he just needs to get that out, and he needs to be able to get it through that, and he needs to be able to move on. But he's never been able to let any of that out. As far as the protection order, he's not going to hurt me when he's sober. He's never tried to hurt me when he's been sober.
Ma'am, here's what I'm asking for your input on. The protection order, you've been married for 32 years. You're saying this is the only time. I can order a protection order where I do not allow face-to-face contact and I do not allow him back in the home. Is that what you're asking for?
No.
Okay.
He won't be allowed to come back where we're staying right now. But
thank you for the sparkles, Kelly. Thank you.
I just feel that I'm not ready to give up on him yet.
And ma'am, I'm going to hear from the people, and then I'm going to hear from the defense, and then I'll make a decision. Mr. Etherly.
Your Honor, I don't object to a PR bond. I am asking for pretrial supervision with moderate sobriety, no drugs, no alcohol. Sounds like alcohol is an issue here. I believe there's a request for alcohol treatment in addition to mental health treatment.
Remember, Judge, this is the first time in 38 years. And then also remember her saying, he never tries to hurt me while he's sober. Oh, Gina, thank you so much. Thank you.
No drugs, no alcohol, no weapons. And I certainly respect and understand the victim's position regarding protection orders and contact. But there was a weapon involved here, and that does concern me quite a bit. So I'm going to ask for at least a cooling off period for no contact at box 1.
Josh, thank you so much for the gold coin. I won't hurt you when I'm sober. I won't.
Through 8 protection order and a finding of domestic violence and use of force. But I am asking for no contact at this time. I wouldn't feel comfortable basing the victim's safety off of the defendant's sobriety. And it sounds like that is quite a big issue. Thank you.
Ms. Bramble, I would do a PR bond.
Okay, Your Honor, then I think we would need a civil assessed.
All right. So the court's going to do a $2,000 personal recognizance bond. Conditions of that bond are pretrial services, no alcohol or drugs, no weapons, no contact with the exception I'll make in a moment with Ms. Fuquay, a monitored sobriety at pretrial services discretion on making a threatened use of force as well as ordering a firearm relinquishment. I am going to order our boxes 1 through 8. What that means, sir, is you cannot harass, intimidate, or retaliate against Ms. Fuquay, cannot be in the same home as Ms. Fuquay, cannot have face-to-face contact. I'm making 2 exceptions. One is a civil assist where you can contact the police, get your belongings from the home, but you can only do so when the police are present. The second one is I'm going to authorize electronic communication. That can be by phone, text, or emails.
The answer to that question, Bobby, is always. Whether you ask me in the morning or the evening or the middle of the day, maybe. Maybe is always the answer.
No weapons, no ammunition. I'm ordering firearm relinquishment both as a condition of the bond and as a condition of this protection order. No drugs or alcohol. And sir, no harming of the dog in this case. This will be reset for filing of charges on August 6th at 10 a.m. in courtroom 110. So that is an in-person hearing, and that completes that matter.
And Judge, did you find DV and VRA for that protection order?
Not out loud. By circling, yes. So it is a DV finding and a VRA finding.
Thank you. Up next, we have Macina Cisneros.
Anthony Messina, Cisneros, 26M 4021.
One moment. Court does find probable cause for arrest. Mr. Etherly?
Thank you, Your Honor. There is a request here for a high cash bond and GPS, as well as protection orders for two sons that may have been present. They are under 18. So if the court was going to consider it, I do have their names. I can provide that, and their dates of birth. I can provide it to pretrial if needed. The victim does have safety concerns and is asking for no contact and GPS, with a DV history, threats to kill, and an objection to a PR bond due to the threats, and that all four children be protected by protection order.
People, I don't have any of the children's names in the affidavit.
I don't, yes, they were not in the affidavit. Two names were provided to me, and I can provide those if needed.
They're going to be needed. I'll have you do that to the chat function and you're saying they're witnesses?
That's my understanding.
All right. And your bond argument?
Your Honor, I won't object to a PR bond. I think the GPS and protection orders may certainly be appropriate. What's concerning here, the defendant said he would not stop harassing her even if there was a protection order. So I'm certainly going to ask for a full no contact protection order so that if he continues to harass her as he's indicated, it will result in a protection order violation. No weapons, no contact with Lori Gonzalez, a box 1 through 5 protection order, a DV finding, comply with the protection order, and I'm going to get no contact. And I will relay the two names that I received to pretrial.
Are they minors or not?
Yes.
And are they the defendant's biological children? Because I don't have anything in the affidavit to make a compelling state interest that he can't have any contact.
I don't have that information.
Your date of birth? You can't tell me, looking at their date of birth, whether they're minor children or not?
They are minors and I have their date of birth, but I don't have additional information about whose children they are. I believe they might be. I don't know, actually. Sorry.
All right. Ms. Bramble, and I'm not inclined to do a PR bond in this case.
Well, Your Honor, I will incorporate the statutory and constitutional bond argument in Gilpin 26 CR 96 into this case. Your Honor, Mr. Mencina Cisneros is a CPAT 1 with limited history. None of what is in his pretrial report is listed with domestic violence tags. And so, I mean, as far as a DV history, I'm not sure how accurate that is. There are no failures to appear in his history and a successful 6-month term of probation from 2024. So all signs point to he can be safely monitored in the community. I will note that the quote that the people attributed to Mr. Mencina Cisneros was not one of the text messages. It was hearsay from the alleged victim. And so I wouldn't say that that statement is documented or proven, but it is an allegation at this point. I'll also note that Mr. Mancina Cisneros doesn't have the financial means to post a monetary bond. There are 4 children that he is financially responsible for. He's been in Colorado for his entire life, so his entire family and life is here, including those children. So all financial resources are going to the care and custody of those children. Putting money towards a bond would mean that he cannot provide that money that he puts up to the care of those children. While he was living with the alleged victim, he is able to stay with his grandmother in Thornton, to stay separate and apart with the alleged victim, but would ask for a civil assist so he can get his things during the pendency of the case. He has been living in the same place for 3 years. I think that also points towards significant stability and no intentions to go anywhere else. He's employed at an orthopedic center as a medical assistant. He's been there for 8 months. Before that, he was in school, and his next shift was supposed to be today. And then he works again on Monday. Of course, he's missing work today, so he's concerned about being able to maintain that employment. If he misses Monday, certainly he will probably lose that job. And again, that will have kind of a rippling effect on being able to provide for his children as well. He has 3 brothers in the state. He has nephews. He has pets. He has, like I said, his entire family here and a lot of community around him. He also watches his kids during the day while the alleged victim goes to work. And so while there will be a protection order, there will probably, we would ask for some sort of carve out so that they can still have those child exchanges, because it sounds like that would probably affect the alleged victim's employment as well, while not having that child care during the day if Mr. Mancina Cisneros has been the one providing it. He does have a car. He's also able to do rideshare or public transit if necessary to make sure he gets to and from court or anywhere he needs to for compliance. I would agree with the court. I don't think there's enough information in the affidavit to bar him from contacting his children, so we would object to that. But ultimately, he has significant stability, limited history, and everything on paper to suggest that he would be able to be safely monitored in the community. There are non-monetary conditions that the court could put in place to address any concerns, such as a GPS monitor, which is a pretty heightened condition and an expensive condition if necessary. It wouldn't be the first thing that we request, but certainly before a monetary bond, that would be something the court could employ. So ultimately, we are asking for a PR bond, and we are asking for a civil assist as well.
You're going to pay for a monitor instead of putting up a bond that you get back if you show up for court. You're going to pay for a monitor every month? That doesn't make sense.
Well, we would object to any sort of cash-only bond setting.
I will set the bond at a $2,000 PR bond. Pretrial services, no alcohol or drugs, no weapons, no contact with Lori Gonzalez. I am going to order GPS prior to bonding, and Ms. Gonzalez needs to be advised by the people that number one, this will be reviewed every 2 months, every second hearing. But number two, this is an after the fact alert. So in other words, the person who just went through your house, you get warned, was Mr. Gonzalez. So GPS is not very effective unless it is just going into an area and getting warned that he was in an area he wasn't supposed to be. So that needs to be made very clear so she protects her own safety. And that's the reason for that warning. Pretrial services, no alcohol, no drugs, no weapons. Monitored sobriety, pretrial services discretion on making a threatened use of force and ordering firearm relinquishment, both as a condition of the bond and the condition of the mandatory protection order. Making a domestic violence finding and a VRA finding. The protected party is Lori Gonzalez, May 5th, 1991. It'll be boxes 1 through 7. Sir, that means you can't harass, intimidate, or retaliate against Ms. Gonzalez. You may not have any contact with her whatsoever. Face-to-face, cannot be in the home, or any other option other than this one exception. I will authorize one civil assist. That means you have to contact local law enforcement, schedule a time for them to be present, and you can get belongings from the house. You may not be at the house without them present. No weapons, no ammunition, relinquish firearms, and no drugs or alcohol. I'll enter a box 1 only for the 2 witness children that were witnesses. I cannot make a compelling find a compelling state interest to limit contact with those children. I am making a VRA as to the children. So it'll be box 1 only, sir. What that means is you cannot harass, intimidate, or retaliate. Any violations of any of these conditions, including the no contact orders and violation of GPS, can result in misdemeanor charges or potentially felony charges. This will be reset for an arraignment on September 8th at 9:30 a.m. in Division D, and that'll conclude that matter.
All right. I got a notification. I don't know if the date of birth for the victim was read wrong, but that is May 9th, 1991.
And state that again. I have the date of birth for Miss Gonzalez. I don't have the names or dates of birth for the 2 children. That's what you're going to provide in chat to Miss Hernandez.
Pretrial's also going to need the names and date of births, otherwise we cannot serve those protection orders. So we're going
You need to provide those to Miss Hernandez and to pretrial, and you need to do that now so they can serve him. Court's going to take a brief recess. Mr. Etherly, you have not provided the names and the date of birth to the children to Miss Hernandez, so she can include that on our end with a protection order in that last case.
I did provide those to,
and just to be clear, you need to also provide it pre-trial and again to Miss Hernandez. She's the clerk. You'll see it. It says Claudia Hernandez. That needs to be provided to her.
Your Honor, he did provide it to the pretrial officers and we were able to serve those protection orders.
Understood. The order of the court had 2 parts to it.
just did, Your Honor.
And pre-trial when you're ready.
Up next, we have Whiting for filing.
Austin Whiting, 26 CR 1386, Ms. Bramble.
Thank you, Your Honor. We will wait for the reading and advisement. Ask that the public defender be appointed while he remains in custody and for a preliminary hearing date within 35 days. I also want to put the people on notice that I believe Mr. Whiting is working on a consent of surety, so he will want to address bond in the near future.
All right. I'll find that rating's been waived. I'll appoint the public defender, finding the defendant indigent. I'll reset this for August 12th at 9 a.m. for a preliminary hearing. This is a Division B as in boy, 5 case, and that'll conclude that matter.
Up next, we have Mueller for filing.
Austin Mueller, 26 CR 2612, Ms. Bramble.
Thank you, Your Honor. I would wait for the reading and advisement. Ask that the public defender be appointed while he remains in custody and for a preliminary hearing date within 35 days.
Court's going to find that rating's been waived. Public defender is appointed, finding the defendant indigent. This will be reset for a preliminary hearing on August 26th at 9:30 a.m. This is a Division D 14 case.
Up next, we have Nicole for filing.
This is Anthony Nicoli, 26 CR 1455. Ms. Bramble?
Thank you, Your Honor. I will waive further reading and advisement, ask that the public defender be appointed while Mr. Nicoli remains in custody and for a preliminary hearing date within 35 days.
Find that reading's been waived. I'll appoint the public defender. Finding that the defendant is indigent, this will be reset to August 26th at 9 a.m. And for a preliminary hearing, this is a Division D 14 case. That'll conclude that matter, sir.
Up next, we have Arroyo Jackson for filing.
And this is Ryan Arroyo Jackson, 26 CR 1448. Ms. Bramble?
Thank you, Your Honor. I will waive further reading and advisement, ask that the public defender be appointed while Mr. Arroyo Jackson remains in custody and for a preliminary hearing date within 35 days.
Appoint the public defender. Finding the defendant indigent, reading's been waived. This will be reset for a preliminary hearing on August 26th at 2 p.m. This is a Division D8 case.
Up next, we have King for filing.
This is Deshaun King, 26 CR 1452. Court, or Ms. Bramble?
Thank you, Your Honor. I'll waive further reading and advisement, ask that the public defender be appointed while Mr. King remains in custody and for a preliminary hearing date within 35 days.
Find that reading's been waived. The defendant is indigent. I'll appoint the public defender. This will be reset for August 26th at 9 a.m. for preliminary hearing. This is a Division D 14 case.
Up next, we have Lizardi.
This is Lauren Lazardi. Court finds probable cause for arrest. People?
Your Honor, I believe the victim is on WebEx and would like to address the court.
And is that Miss Bessie Tapia? Miss Tapia, can you tell us your name and then what you would like me to know?
Bessie Tapia.
If I had to guess, I would say no, but I could be wrong. No, I don't think this is magistrate court.
And I will be dropping
This is initial appearances, though.
all charges in regards to the protection order. It was already supposed to be in place.
Miss Tapia, thank you very much. People?
No objection to a PR bond with no weapons, a box 135 protection order, DV, and to comply with probation. Thank you.
I'll do a PR bond. I just be blunt, I can't make a DV finding based on this record. Ms. Bramble.
Well, Your Honor, if there is a new protection order, I think that we may need a civil assist, but other than that, nothing further.
So I'll set bond at $1,000, personal recognizance bond. Court cannot make a DV finding. It clearly was consensual contact. That's what Ms. Tapia is saying today as well. What I am going to order is that the defendant, and that's is to comply with all mandatory protection orders that are in place. That protection order is still in place. You cannot have contact with Ms. Tapia of any type until that protection order is modified. Ms. Tapia does not get to decide whether charges are filed. That is up to the people of the state of Colorado, specifically the First Judicial District District Attorney Office. And they will be the ones who decide whether to go forwards on those charges or not. So that mandatory protection order is still in place. Any violation of that can result in another misdemeanor charge or potentially even a felony charge. This will be reset for arraignment on September 8th at 9:30 a.m. That'll be in Division D, and that'll conclude that case.
I'm sorry, Your Honor, was a civil assist authorized?
I didn't enter a new protection order. I just ordered complying with the mandatory protection order in place. I'm not modifying that protection order in any way.
Okay, Your Honor, I think, looking at what's listed in the affidavit, actually, I think that he might still need one because it does appear that they were living together previously, so I'm not sure if
I am not modifying a protection order that's already in place. That he has to comply with that. If he's been violating in that and choosing to live in that home, that's a different issue for that court and that protection order. But I am not modifying it. I did not add a new protection order today.
Good job, Judge.
I understand, Your Honor. I was not asking the court to modify a protection order. My understanding was that a civil assist could be a condition of bond, not a modification of the protection order.
I'm not going to do that today.
Nice try.
Up next, we have Medina.
Foggy cold.
Trying to make sure I wasn't missing out of county warrants. This is Christopher Medina, 26M 3770. Court finds probable cause for arrest. Mr. Etherly.
Thank you, Your Honor. I believe
That poor last name. Well, it's funny because we were just talking about last names. Tilapia. Even though it would make me starving every day if my name was Ms. Tilapia, I'm glad it's not Miss Medina. Every Gen Xer would be always singing at me.
the victim is on WebEx and would like to address the court.
And is that Ms. Portillo?
Yes.
Ms. Portillo, if you would state your name for the record and then please tell me what you would like me to know.
I'm Vanessa Portillo. I just wanted to say that I don't.
All right, V. You know, you said that there's a lot of DV cases in this court. No. Every docket, every day, in every court is like this. We just cut them all out for YouTube and just get the, the bigger ones. But this is every single docket, every single day, in every court. It's all DV, DV, DUI, DV, DUI, DV, DUI, and child, issues every day. It's crazy.
I think he deserves to be in jail.
I think every single woman should just always have pepper spray or worse. Always.
I think he just made a mistake, and that doesn't define who he is as a person. He's really good to me. He helps me. He takes off of work and so I can work, and he watches my kids for me because I have no one else to help me. He's helped me out a lot. I've been with him for 1.5 years, and he's a good dad. He's there for his kid. He's at his games and his practices, and I don't think him sitting in jail is good for anybody. And I think he just made a mistake.
Ms. Portillo, thank you very much. I'll hear from the people and then from the defense, and then I'll make a decision on both bond and then any protection order.
Okay.
Mr. Etherly.
No objection to a PR bond with no weapons. I am asking for no contact or at least a cooling off period. A box 1 through 6 protection order, comply with the protection order, and a finding of domestic violence and use of force. Thank you.
Ms. Bramble, I would do a PR bond in this case.
That's all we're asking for, Your Honor.
Court is going to order a $1,000 personal recognizance bond. Conditions of that bond are pretrial services, no drugs, no alcohol, no weapons, no contact with the victim, in this case, Ms. Portillo. I am making a physical use of force finding in order relinquishment of any firearms. I'm going to enter a DV finding as well as a VRA finding. I'm going to order a protection order for Vanessa Portillo. And that order is going to be no face-to-face contact and cannot harass, intimidate, or retaliate against Ms. Portillo. Cannot be at her home, have face-to-face contact. The affidavit says you guys have separate living homes, so I'm not authorizing a civil assist. No weapons, no ammunition. And the court is going to order a firearm relinquishment, both as a condition of the bond and a condition of the protection order. This will be reset for an arraignment on March 15th at 9 a.m. in Division D, and that'll conclude that matter.
I'm sorry, Your Honor, what was that date?
March 15th. Oh, golly. Ms. Bramble, that was kind of you to say, excuse me. What was that date? And not what in the world were you thinking? September 15th at 9 a.m. That would be in 2026, just for the record. And that concludes that matter.
Up next, we have Mosley.
This is Robert Mosley, 26 CR 1486. Court finds probable cause for arrest. Mr. Etherly.
Thank you, Your Honor. I'm asking for a $2,500 cash bond. The defendant is a CPAP 1 with limited or no history, but I do have community safety concerns based on the allegations. It looks like he was soliciting girls. I think the estimated age was between 9 and 12.
This is Joshua Rocheau, 26 CR 1488. Court finds probable cause for arrest. Mr. Etherly.
Thank you, Your Honor. I'm asking for a $500 cash bond. You know, the defendant is a CPAT 2. There's 23 previous failures to appear, so I do have concerns about future court appearances, retrial supervision, live monitored sobriety, no drugs, and no alcohol. Thank you.
And Ms. Bramble, your request.
Thank you, Your Honor. We would object to any sort of cash-only bond setting. I would incorporate the statutory and constitutional bond argument in Gilpin 26 CR 96. As to Mr. Rocho individually, it looks like he's 33 years old and has a working phone number. Stay in contact with anyone that he needs to stay in compliance with bond conditions. Additionally, he right now does have a growth on his brain that's being monitored by doctors. And so he is concerned about being able to schedule and receive follow-up care, which he isn't going to receive in the jail in a meaningful way. He does also typically have a methadone regimen that he wants to make sure he can stay in compliance with as well, since it's important to him to try to keep making those efforts towards a lifestyle of recovery. He is taking classes at Denver Health. He goes in every morning and has been there for about 4 years. He owns his own company doing landscaping and snow plowing. He's been doing that same work for 12 years in this area. He has his own stable apartment to live at. And
I wonder if he wants to borrow my snowblower for his business. I would let him.
And additionally, he's been in Colorado for his entire life. His entire family is here. He has joint custody of his son and does financially support his son and have parenting time. For transportation, he does have an e-bike that he uses, so he would be able to make sure he gets where he needs to go to stay in compliance with bond conditions or the court. So overall, he does have pretty significant stability. in the ability to make sure that he is compliant in the community. So we would ask that the court give him a chance on a PR bond. We would object to any sort of cash only bond setting.
Court will set bond at $2,000 cash or surety. No, conditions of the bond are pretrial services, no drugs or alcohol, no weapons, monitored sobriety at pretrial services discretion. This will be reset for August 6th at 10 a.m. and that'll be in courtroom 110, and that'll complete that matter.
Up next, we have Reardon.
Sean Reardon, 26M 4023. Court does find probable cause for arrest. Mr. Etherly.
Thank you, Your Honor. I believe the people filed a motion to dismiss in 26M 3719. I think he may have been given a summons and then shortly after been recharged here. So that should be the same conduct. But regarding this case, I'm asking for an $8,000 cash bond, Your Honor. He's a high-risk CPAT. It's a 2026 protection order violation, 2026 CR criminal mischief, the same victims. And here, these are protection order violations, but they are concerning. The protection order in part stems from that criminal mischief where he took a sledgehammer to the victim's car. And here he was found with 2 guns, a rifle and a loaded revolver. There's concerns about his mental health and meth use. So I do have victim and community safety concerns given the weapons and the drug use here and the number of cases from this year. In addition to the $8,000 cash for trial supervision with monitored sobriety, no drugs, no alcohol, no weapons, no contact with Steve and Julie Irk, and new protection orders, boxes 1 through 5 and 7 for them, comply with protection orders, and do not return to 10352 West 75th. Thank you.
And that address again?
Cloud. It's so nice to see you. No, you're not here to darken our day. How are you feeling? How are you? It's been a while.
10352 West 75th.
And Ms. Bramble?
Your Honor, I will incorporate the statutory and constitutional bond
It was just
argument
a mistake.
26 CR 96 into this case. As to Mr. Reardon individually, the people start off by saying that this was sort of a refiling of the same or similar conduct from when Mr. Reardon was on summons. Go from being on summons to an $8,000 cash only bond is a pretty significant jump. More appropriately, the step up would be a PR bond with secured conditions. So
I think sledgehammer is a step up there.
Mr. Reardon could show that he can be safely monitored in the community. I will note that he does have a stable phone number, has had the same phone number for 3 years to make sure he can stay in contact.
Walter.
The lawyer, if he chooses to have one, or the court notification system, pretrial, anything he would need to stay in compliance with his bond conditions. It looks like he did previously and most recently complete probation successfully in a 2020 case. So that also goes towards he can be safely monitored in the community as he was then. Additionally, I do think that mental health is probably a significant factor here just based on the affidavit. It looks like some of the witnesses who spoke to Officer Gonzalez talked about working with mental health corresponders up to that point to try to help Mr. Reardon. And so I think that's a really important piece for Mr. Reardon to be able to have access to any kind of treatment. It would be much more accessible to him out of custody rather than in custody, where he may not see a provider for weeks at a time. As far as work, he was helping to take care of his parents. It sounds like his dad has a dementia diagnosis. And while his mom is his dad's primary caretaker, he was helping around with that. He does not live with anyone involved in the case at this time. And so he would be able to stay separate and apart from anyone involved in the case. He has been in Colorado for his entire life. His parents are here, his daughter's here, his sister's here. He also volunteers with Arvada with their CERT team. So ultimately, he does have pretty significant stability and community around him. He does own a car and is able to get to and from wherever he needs to stay in compliance with court conditions. And so ultimately, I think the court can ensure Mr. Reardon's safe monitoring in the community with non-monetary conditions, conditions like not owning weapons, pretty simply, as well as any other sobriety monitoring or a mental health evaluation that the court might find appropriate. All of those things certainly would be able to secure Mr. Reardon's supervision more than a monetary bond. So we would object to a cash-only bond setting. We would ask the court for a PR bond.
And parties didn't mention this, but I have that he has 26 CR 1263. Competency was raised in that case. I'm not raising it in this case, but I am going to set bond at $5,000 cash for surety. Pretrial services, no
That's so
alcohol or
cute.
drugs, no weapons, monitored sobriety at pretrial services discretion, no contact with Steve and Julie, Irk, or Jewel or Julie. I have it spelled Jule. And court is going to add as a condition of the bond to comply with the in-custody competency evaluation that was ordered out of 26 CR 1263. I'm making a VRA finding as to both Irks. This will be reset for an arraignment on September 8th at 10 a.m. And that's in Division D, and that'll conclude that matter.
And Judge, did you order new protection orders?
I did I didn't give you the boxes. It's 1 through 5 and 7 for Steve Irk and Jewel or Julie Irk.
Your Honor, the last, I think, 3 we've been told are refusals. I can let the court know what we've been told.
I'm sorry, say that last part. You'll let the court know.
I can let the court know what we were told. Sorry.
Okay. I'm just writing down the date right now for the Irks, and then we'll do that. Court will call Quinn Beckett. And pre-trial, they are refusals?
Correct.
All right, so Quinn Beckett, 26M 4019. Court does find probable cause for arrest. Ms. Bramble? Or Mr. Etherly? Was there anything you wanted to address?
Not for this case, Your Honor.
Not at this time.
We'll set this over for Monday. It'll be August 3rd. Maureen Reynolds, 26 CR 1487. Court finds probable cause for arrest. And what type of refusal is this?
Detox refusal.
So detox. Court will set this over to Monday, August 3rd.
All right, we did it. We made it to the end. Thank you so much for coming out today, guys. I really appreciate it. I'll see you in 22 hours. We'll have some more. Let's do court videos tomorrow. I hope that you guys have a great day. Please try to be nice to someone today. Please. We need it. We really, really need it. And I'll see you tomorrow. Behave, guys. Bye.
Well, I thought thought I'd write a happy song. I found a chat room where I belong. You don't know how much it means to me. With such a groove, I'm less lonely. Oh, Kathy's the creator, she's leading the way. At court vibes, we laugh and we stay. Her smile shines bright, she's got that grace. Come join the fun, it's a welcome and play. I can count on distraction from my pain, 'cause this creator takes you there and back again. Kathy is the heart here, always in stride. Her work is hard, but her joy she can't hide. Oh, Kathy's the creator, she's leading the way. At court vibes, we laugh and we stay. Her style is classy, she's always top shelf. Don't take my word, come and see for yourself. Her cases are new with a twist or two. I really like them, I believe you will too. A little lifeline passed along in rhyme. Why don't you join us? It's a guaranteed good time. Oh, Kathy's the creator, she's leading the way. At court vibes, we laugh and we stay. Her smile shines bright, she's got that grace. Come join the fun, it's a welcome